topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Orlando. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. Hey, before we start the show today, I got to give a little love out. I have never, we've been with W4CY for about the last 2 years, and I just want to thank our producer Juan, who does our shows on Thursdays and Fridays. I don't ever think I thank him enough. Every time I've got a problem, he's always there for me, and he's just a good guy. So love out to my great producer. Now, right before the show, we were doing a little bro love before the show. And I got to tell everybody because, we get so many emails and texts about our shows. The K-Bender Rimbaum shows, without a doubt, get more texts and letters than any of my 35 shows. Actually, more than the shows we've been doing for the last 15 years. But our expert today, Alan Attorney, board certified attorney. I will never leave that out. Board certified attorney, Alan Swartseed. I got to tell you, the letters that come in about him are absolutely amazing. And first of all, we want to thank you for taking the time just to write a letter saying, love the show, love Alan. He's been a great help to us. We actually have people who listen to his show, board members, that it's a requirement to listen to the show. I don't even know if I've even shared that with Alan. I have with the senior partner, Robert Kay, but there's actually board members that it's a requirement that they listen to the show. But people love Alan. Let's welcome him to the show. Board certified attorney, Alan Swartseed.
You're gonna make me blush here, Steve.
Go for it, bro. Listen, you know what? When you're good, you're good. I do so many shows. We do 3 a month with Kay Bender, but we do 35 shows a month. And the response that we get for Kay Bender Rimbaum and the response we get for your show, after 15 years of doing these, I'm just blown away. And, some of them are even your clients, and they tell us what a great job Kay Bender Rimbaum that they do for them, and they feel so lucky to have your firm. So, why not share the love, huh?
All right. Well, I appreciate that. And no, I was not aware that anyone had made listening to our shows mandatory, but I think it's probably a good idea. You spend 3 hours every month paying attention to current events in this community association industry, because keep in mind, you've got mostly people who are not experienced in business that are on a lot of boards of directors for condos, HOAs, and co-ops in Florida. And it's, there are plenty of people that are experienced, and I think that's fantastic that they're willing to give back and volunteer their time, just like we are here today. But, at least one of us is, Steve. And but I do think it's important that that education piece is always very important to our firm, and it's really great to hear that people take it seriously, because you have your requirements, and it sounds really ominous and onerous to have to sit there if you're in an HOA and do 3 to 4 hours every couple years, and do 4 to 8 hours a year. But even if you had to do all that in a year, it's 12 hours out of the entire year to make sure you're doing this right. I think adding another 3 hours a month, it sounds like a lot, but again, that's 3 nights where you spend an hour with people like me and Steve. I think it makes
Right.
sense, but
And you guys do so many different. One of the things you do is your certification classes, and we get a lot of emails, people saying how much they enjoy the certification classes. And what's amazing is they're even longer. They're longer now than
I
they
know.
used to be, and the people still love them.
Well, I just did one with Kirsten out in Tampa. I don't remember if it was yesterday or the day before. I mean, those things are brutal, man. I can't
Oh
even
yeah,
teach all 4 hours. I can't imagine people sitting through and listening to all 4 hours, but that's part of why we give the materials afterwards so that people have something to refer back to. Because, I mean, listen, I get that that's what the legislature wants us to do. I think in reality, we could easily make it 8 to 12 hours and still not get through everything I'd like all board members to know. But at least now it's mandatory that people at least learn a little bit about what they're supposed to know in order to do this job properly. And while you're not getting paid for it, it is a job.
you guys do. I think it's called Ask a Lawyer.
Ask an
Uh,
attorney. Yeah.
Ask an Attorney, and I've been to actually several of them that Robert and Michael have done, and I'm actually sitting there in the audience, and the people come there, and one of the guys said, "You know what? I only have a couple questions. I got to tell you that 1 hour presentation, first of all, turned into 2 hours because here's one person, his two questions turned into 8 questions. And people love when you guys do that.
Oh, well, I will tell you. So we're planning some of the upcoming seminars for July and August, and I always plan to not schedule anything for at least a half hour after that seminar is supposed to end, because I
Yes,
know realistically, yes, we're going to go through the information, but there are going to be more questions because we explain things that, as you've mentioned to me in the past, we explain it in plain English, but it leads people, instead of being confused, to just have more questions that they want answered so that they can understand better. And I think that it's difficult for a lot of attorneys to explain things in plain English, especially those that do a ton of litigation like I have in the past. I'm very fortunate that the firm doesn't want me doing that right now. But I spent 15 years in the courtrooms, and you have to explain things very differently for a judge than the way that you would explain it to a client. And I think that that's one thing that our litigation team does really well, but it's something I've learned to do, is speak in plain English. And I was speaking with someone about this just today. One of the clients that I met with said, you really make it understandable without making me feel like an idiot the way that I'm asking the question.
right.
And I think that's a skill that almost, I certainly won't say it's more important than being able to give the correct answer, but it's almost equally important that, it's more important that people understand the answer, especially if they're going to try and use the information you're giving them to formulate an opinion. And a lot of times, you're not telling the board what to do as an attorney. You're telling the board, here's what could happen if you don't do it right.
Well, here's something else. I don't know if you're going to be shocked at this or not, but we do the show all across the country. So we're probably maybe 25, 30 cities. And I got to tell you that community association law is becoming bigger and bigger. But here's the problem that these associations need to be aware of. There's a lot of law firms out there who are just sticking up on their uh, shingle that they specialize in community association law, which they maybe have done one or two cases. This is all K Rimbaum does.
Yeah, I mean, at KBR, this is literally all we do. We and 90% of the time, I'll be candid, we're representing the association, if not more than 90% of the time.
Right.
But again, this is not something that we dabble in. And frankly, because it's so specific and so statutorily and case law driven, it's not just read through the documents and you've got your contractual answer in this area of law. It's truly if you're not knowledgeable about what to look for, I've heard other people make the comment, you don't know what you don't know, and that makes it dangerous. And that's what I tend to see happen. And I think most people in this industry tend to see happen when you deal with a dabbler. We don't,
Yes.
we do the work and it's all we do.
Well, I want people to be aware of that it's so important that you go with a firm like K. Bender Rimbaum, a firm that this is all they've done. How many years has K. Bender Rimbaum been
Since the
around?
early 90s, I think it's over 30 years.
Wow. Well, I got to tell you, what we do here, if you've just tuned in for the first time, we get so many questions from you, our listeners and our viewers, and we compile those questions up, and it's no way we could get them all in. And we also take
We'd have a
questions.
5-hour show, Steve.
Yeah, right. No kidding. And we also take questions on our YouTube. Here's the deal. I know we're going to get questions today about the new laws. We're not going to handle those today. We're going to wait till next month because that was just signed off on by the governor. But I see our first question up there, Alan,
Okay.
from Todd. One assessment was done that included line items, electrical upgrade, structured ELSS. Is that considered one assessment where we can allot money from our own budgeted item to be under budget to an under budgeted item?
Well, if you don't use the full amount, for example, somehow you get a deal or it doesn't take as much work for the vendor to do the work that special assessment was supposed to pay for, then the short answer is, yeah, that becomes pretty much operating funds. Some communities will demand, and when I say communities, I really mean the owners will say, you didn't use all that money, you need to give it back. Well, no, you don't. The reality is that becomes operating funds of the association. If you know that project will come up again, you can kind of make that an unofficial reserve, but nothing says that the association must do that. It's really, those are operating funds going forward. So the short answer to your question, I think Todd was the name. The short answer,
Yes.
Todd, is yeah, you can use that for whatever you want, as long as that project is complete and you've used as much of that special assessment as needed to complete that project. If you still have that project ongoing, then I would keep that money for its intended purpose, because otherwise then an owner might have a problem and might have a valid claim.
Let's go to Carl in Orlando. At what point does your email become part of the condo records and become public? When you registered with the association or just by sending an email to the association?
So that's still kind of up for debate. And the reason I say that is because there's nothing in the statute that clarifies whether those emails qualify as official records and when. The statute basically says, and this applies to condos, co-ops, and HOAs. So when I say the statute, I really mean all three individual statutes. They all say that the written records of the association are the official records. And those are written records pertaining to the business of the association. That could be pretty much anything. The question is whether an email is a written record or it's an electronic record that's not written. My opinion has always been that once that email is printed, it's clearly a written record. But there is question, and frankly, DBPR, which is the government entity that rules on these types of issues, they've gone in both directions. There's no court case law deciding when an email becomes an official record. My perspective is if it's been printed, if it's been shared outside of the board and management, it probably is an official record of the association. So if it went out, meaning it's an outward going email, if it came in from someone other than the management firm and the board between each other, that probably will qualify as an official record. But again, it could be every email, even internal to the board, with the exception being, obviously, if it's for potential litigation or at the direction of counsel, you've then got a potential privilege issue that makes it an official record, but still exempt from being produced to the members. So that's a lot of words to say the law doesn't make it clear.
Do you think it'll ever get tied down, though?
I think eventually it will, when someone gets fed up enough that they say, we need these emails, and someone decides to appeal a decision either of the arbitrators and DBPR or of a court up to a higher level, and then we'll have case law that's on point. But a decision by a county court or by a circuit court within the state law system, that's not going to be it's not going to be a decision that you need to rely on. I'm trying not to use legal terminology and put it in plain English, but that wouldn't be something that every court then needs to follow until it hits the appellate level, which hasn't happened yet to my knowledge.
I got to tell you, we just got a text in from Christy in Orlando. I am on the board of my association. We actually use K. Bender Rimbaum, and we had another firm before them, and that's why we have K. Bender Rimbaum now. And they are, without a doubt, the best. We love your show. We listen to it all the time. Please, people, if you're looking for this, I know you had to have a relative write this. If you're looking,
I had nothing to do with this one. I didn't even know it was coming.
That is really sweet. Thank you, Chris.
Thank you very much, Chris.
Yeah, really. Let's go to Trey in Orlando. Our condo's governing docs were filed in 2002 without Kaufman language.
Okay.
If we revise them in 2025 without Kaufman language, will 2002 or 2025 a law apply to us?
So if you're going to add that Kaufman language to the declaration, and for those listening who haven't heard us talk about this 8,000 times,
yes,
Kaufman language is that language that you might have in your governing documents that incorporates the Condominium Act, Chapter 718 of the Florida statutes. And here's the important part: as amended from time to time. So it's that as amended from time to time language that's important, and it needs to specifically refer directly to the statute or the Condo Act in order for what we're saying right now to apply. Usually, procedural changes in the statute, these amendments that the legislature makes every year and kicks us around and kicks the can down the road as to what we're required to do and not required to do, those statutory amendments, if they are procedural in nature, meaning how you go about doing something, those will all apply regardless of whether you got this language in your declaration. But if it's a substantive right of the association or the owners, meaning you're not allowed to enforce XYZ anymore in a Florida condominium, that's a substantive right. Okay. If you've got covenants, rules, and regulations, and the legislature says you can't have those anymore, and if you have them, you can't enforce them. If the legislature does this and you have Kaufman language, that statute will apply. If you don't have language in the declaration that says this, then generally speaking, the statute that was in place as of the date the declaration was recorded is the one that is relevant to the legal analysis. That's a lot of words. I'm going to move on to the actual answer to the question now. If you made that change and you amended your declaration in 2025, my opinion is every statutory revision that's been in place before 2025 will apply to your association, and so will all of the ones that apply going forward. So every statutory amendment will now apply to the association. So the question of what statute applies, well, the newest one is really the answer once you make that amendment. I would recommend against it because we've seen some things that the legislature has done that don't make me very happy about representing associations and having my clients have to deal with certain issues that, in my opinion, they shouldn't, especially some of the changes to the HOA statute over the last year I've considered pretty, I'll call it draconian, but it's draconian against the association instead of protecting the interests of the owners. It's protecting the interests of individual owners instead of the community as a whole. So again, short answer, if you put that amendment in place now, every statutory amendment across the board will apply to your condo. So again, for that reason, I don't recommend it, but it is something that the board can consider. And if the members approve it, have at it. It's all yours.
Alan, we're going to take our first break. When we come back, we're going to go over your schedule. Tell people how they can reach your office.
So the easiest way to reach me is by email. My email's right up on the screen right here. If you're just listening, it's AS, as in Alan Schwartzide, at kbrlegal.com. The other way to reaching the office, you can call us at 954-928-0680. That'll reach any of our offices. That's the front desk in Pompano. And we do have 4 offices for those that don't know us: Pompano Beach, Palm Beach Gardens, my office here in Winter Springs, which is in Orlando area, and another office in Tampa. Also Miami by appointment. 23 attorneys, 8 board certified in community association law, including myself, 1 board certified in construction law. Again, pretty much anything a community association needs, we can handle, but we're not looking to take you away from your counsel if you're happy. So as Christy mentioned, some people are not happy with their current counsel. Those are the ones I want to reach out to me, and I'll be happy to talk to you about how we might be able to help your community operate a little better. But if you're happy where you're at, stay there. No problem at all.
Okay, we're going to go to break. When we come back, we're going to go over the seminars and classes that you've got coming up. We'll be right back.
A lot.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We are here with board-certified attorney Alan Schwartzide. He is with the K. Bender Rembaum. He manages their office in Orlando, the Orlando office. And we started talking about beginning of the show, all the classes, the seminars, the free seminars that K. Bender Rembaum put on every month. And boy, I tell you, Alan, looks like you've got a busy month, and starting the end of this month and going into July.
Yeah, well, I mean, the good news is these aren't all me, but we do have a lot of them coming up. Next Monday at 2 p.m., I'm going to be speaking with Jeff Rembaum regarding association insurance requirements. We've got association leadership coming up July 9th at noon. July 10th is the Educate to Elevate Expo for Castle Group in Broward. The one in Palm Beach is July 16th. July 24th at 11 a.m., we've got a board certification class for HOA directors. July 29th at 11 a.m., I will be joining my relatively new colleague, Chuck Nix, in my office. This will be a webinar for updating your governing documents. He'll be going through some of the generic, here's what our materials are. And then I like to add my top 20 amendments that I think every community association board should be considering to try and make your community operate a little better. So, that's, as usual, our list of 6-7 items. We've got but I think we'll probably end up closer to 15, 20 by the end of the month. We're also working on the schedule for August, but we can talk about that at the end of next month.
Okay. I know we got an email from somebody, which I have down here, talks about what happens if you're elected to your board and you haven't gotten certified yet. How long do you have? So we might as well answer that one now.
Sure. So that is a condo, co-op, HOA, all the same. You've got 90 days from the date you were elected to complete that class. If you don't, sorry, but you're off the board. It's not a board decision. It's a suspension, to be clear. Okay, you're not off permanently. You're off until you actually complete that requirement, which the requirement is not just taking the class. It's making sure that that certificate reaches the secretary or your community association manager and gets into the official records. That's when you get back on. The board can basically sit there and say, well, John didn't do what he was supposed to do in time, so we're going to go ahead and appoint someone else to take his spot until he takes care of this requirement. Now, we've got both classes almost every month, HOA and condo/co-op. I know we've got the HOA coming up next month at least once. I'm sure we'll end up with a condo and possibly another HOA. So, it should not be that difficult. If you go on our website at kbrlegal.com, click on the calendar link, you can register for any one of these webinars for free and take it online. I don't care if you take it in your underwear with a drink in your hand. The reality is it shouldn't be that difficult to get this done. I understand a lot of people work. We try and do them during the day just so that people that, are, frankly, I expect a lot of people to be sitting there and listening in the background of whatever they're doing. But the reality is we're giving you the opportunity to do this for free online and not have to worry about anything. So if you're not willing to do it within 90 days after being elected, my thought process has been for some time, maybe you don't need to be a director of an HOA, a condo, or a co-op, because maybe you don't care enough to put that 3 to 4 hours into it to learn what you need to learn in order to know the absolute basics of being a director.
We just got a text from Ron. He wants to know, I'm thinking about running for the board. I know you can't go into great detail, but what's involved in the certification classes?
So they're different for condo/co-op versus HOA. They go into budgets, elections, collection of assessments, covenant enforcement and violations. There is a statutory list of what these classes need to include. It's very similar from condo to HOA. The major change between the two is that the condo co-op one is going to deal with milestone inspection reports, structural integrity reserve studies, and that's an entire section of the 4 that we teach for condo because the legislature considers it so important. So that's the major change between one and the other. But again, it's, as I mentioned a minute ago, it's primarily here are the absolute basics of how to be a director and not completely screw this up. And the most important thing that we teach during that class is the fiduciary duty, which is the responsibility of every director to do what's in the best interest of the association, even if they don't like it or even if it hurts them. So it's learning, basically the goal of this class is to teach you how to make business decisions rather than making emotional decisions or making decisions on what you think is best for you.
Ronnie in Sanford wants to know, why will the DBRP, which we just talked about, not get involved with HOAs?
So the DBPR generally doesn't get involved in HOAs because they have no jurisdiction over HOAs. There are certain issues with an HOA that they do have the authority to step in, but usually it's going to be primarily with management company issues and not the association itself. The distinction there is that in condo land, they do have that authority. So they just don't have the authority to step in on very many HOA issues at all. There was a push in this legislative session to change that so that they're governing and doing the same arbitration and governance over HOAs. There was a little bit added last year to the DBPR's jurisdiction over HOAs, but really they don't have much jurisdiction at all. And that's the primary reason they ignore HOAs. I won't say ignore, but they don't act when it comes to HOAs because they can't.
Makes sense. Chris in Orlando wants to know, are there any state-funded programs to help condo owners with financial repairs?
I'm not aware of any state-funded programs for repairs. I think there might be federal programs for repairs, but I haven't frankly been involved in any of them. But I know that there is a state-funded program for hurricane protection, the My Safe Florida program. That money's all gone for last year. I don't think they put out money this year, but that money is still in existence, and there's no way of knowing whether in the next legislative session they're going to put more money out there for communities to, they call it hardening, which is basically protecting the building from storms and winds and things of that nature. So I'm not aware of any money that's available specifically for repairs, but that's what loans are for and special assessments are for, unfortunately.
Yes. Lou in Orlando, what can a board do when 100% vote is required, but owners don't participate to vote, yay or nay?
Beg. That's the reality. I mean, if you need 100% member vote and you can't get it, you can't do the thing. I hate to be blunt about that, but there's no way around needing that vote. Now, there are certain things, for example, if your condo is basically destroyed and dilapidated, getting that 100% member vote might not be required if you want to terminate, but I can't even get into detail, and I can't even think of something offhand that wouldn't require you to just go out and get the vote. And if you can't, you just can't do what you wanted to do sometimes. Now, there are suggestions I can make to get a larger percentage of the people to come out and vote, like electronic voting and going door to door and sending emails and things of that nature. But I mean, the problem with 100% member vote is if you've got one holdout or one no vote, you're never going to succeed. Now, you might luck out and get a court to say, well, there's only one person, they shouldn't be able to hold this back. But there's significant risk that the court is just going to say, well, the contract says 100%, or the statute that applied at the time says 100%. So sorry, you're out of luck. I hate when I can't give an easy answer that helps, but sometimes it's just sorry.
John in Winter Garden wants to know, what do you think about a condo property management company not having the financials for the last 6 months because they said they lost an employee? The board thinks nothing of it. I think there's a problem with that.
I think there's a problem with not only the situation, but also the excuse. I mean, almost every management contract I've ever looked at requires the manager to maintain financials on a monthly basis. If they haven't done that for the last 6 months, then not only are they not complying potentially with their contract with the association, but they're also potentially putting the association in jeopardy because you don't know what your financials look like. You can't properly plan for the following months if you don't have the last 6 months worth of what does our money look like? Do we have the funds to do X, Y, Z? That's one of those things that I would talk to your attorney about, because unfortunately, I mean, listen, we generally try and maintain a friendly relationship with management firms, but there are some that'll make these errors. And unfortunately, if that happens, the best course of action might be to terminate, get an audit, and figure out, what do we need to do? And when I say terminate, I mean, look into terminating the contract with the management firm if they're not willing to do what is necessary to get your financials back in order.
Sherry in Sanford. Yeah, we get a lot of letters from Sanford.
It's a great area.
Love your show. Enjoy listening to it every month.
Thank you.
I'm a longtime listener. I want to know, is it legal for two board members to consistently have meetings in the president's home and vote off board members without a quorum in the president's house?
So the answer to whether it's okay to have these meetings of two directors in the president's home depends how many directors you've got in your community. If that's a quorum of the directors and they're discussing or deciding on association business, the statute says conducting association business, then yeah, that's problematic. If the board is voting off directors, that's not something that they get to do. That's called a recall, and it's done by the members. So unless your community is comprised of 3 lots or units, chances are those 2 people aren't authorized to do that on their own. And that director who was voted off, so to speak, would potentially have a claim that they should be put back on the board pending a recall by the members, not by the board.
Alan, do you get a lot of questions from your associations
Yes.
about the website? You do? Yes.
About websites.
Doesn't matter.
General,
doesn't matter what the questions are.
It doesn't matter. The answer is yes. So yeah, about websites and what's required to go on them and who's required to have one. We get a lot of these questions. I mean, the reality is if you're using a qualified management firm that knows what they're doing and is in this industry and cares about, what's going on, chances are their management portal is already doing 99% of what you need. It's just a matter of making sure that those documents get uploaded properly. The only piece that management firms may be missing that they can easily fix is the requirement that all your agendas, meeting notices, and certain other documents that are going to be voted on at those meetings either go directly on the front page of a website or on a link that's on the front page of that website. So those are the questions we tend to get. What do we need to actually put up on the website? And the statute's actually pretty clear on this one. So, my answer to that is always, here's a copy and paste of the statute. I'll keep the fees to a minimum, but if you've got specific questions, let me know what you think is being done improperly or isn't being done at all. Now, as to who needs a website, in an HOA, that's going to be anyone that is governing 100 lots or more. In a condo, right now, it's 150 lots or more. Starting in January of 26, that'll be 25 units or more. So it's going to be most people, and I wouldn't be surprised if we see next year or in the following year that just like the condos, the number that you need to have reduced, that in HOAs, it goes from 100 down to 25 lots as well. So I think that covers most of it. But yes, we get plenty of questions about websites, especially since the requirement for condos and HOAs are both relatively new. In condos, I think it started where you had to have a website if you were 150 or more in 2019. And in HOAs, I think it was just last year.
Did they ever come up with any penalties? I know there was never penalties for not having a website. Are there penalties now?
There might be, but none that I've ever heard of a community having. And in reality, part of that is that the management firms are really helping communities in not having to go out and get a separate vendor to create these websites. The association is required to have a portal, basically, from my perspective, and a front page. If management systems can allow for that front page to be created, or it can be created through some other web portal that leads back to the management portal, you don't really need to do anything else. Where I see it being difficult is with self-managed communities who really did have to go out and find a vendor to do this work. And most of them knew that this was coming down the pike and took care of it.
We have Chuck here in Cocoa Beach, and he talks about our management website could be made better by a first grader. I guess Chuck's unhappy with the website. He said, we cannot find any documents or contracts or anything. What do we do?
Talk to the board about creating an independent website in that instance. I mean, I don't know what management firm they're with, but most of them are fairly easy to navigate. They're definitely not intended to be a $50,000 website that you paid some crazy developer to create for you. The purpose is just to provide the documents to the members. And so frankly, my perspective is if you've got it set up like, Windows Explorer, for the most part, that's good enough for me.
Right.
Where you've just got your file structure and here's the access, have a nice day. That's literally all the statute requires, other than, certain information being there, certain other information not being there, and then having that front page and a separate login credential for each user. There's really not much else that the statute requires. So yeah, a first grader might have done a better job, but the association might not be required to do any more than what they've already done.
Here's a guy that I guess he's got a condo in both the Orlando area and the Tampa area. So
Okay.
he wrote two separate emails. He said, "Can a new owner with dollar laundering conviction 10 years ago from an outside state join the board of directors?"
Okay. So he's really asking, based on the restriction, that someone who's been convicted of a felony or something that, if it happened in Florida, would have been a felony, can't serve on the board. So the 10
Yeah.
years ago is not relevant to me. What's relevant in statutory terms is, when did this person get their civil rights restored? If it hasn't been 5 years, so if they were in prison for 5 years, but it's been 5 years since then, and they had their civil rights restored, they were let out of jail, they were, even put on probation, is okay. But if their civil rights were restored at least 5 years before the date that they can last seek election, that's good enough. So the answer might be yes, it might be no. It really just depends on the circumstances we're talking about here. Was this person released from prison, and were their civil rights restored, as the legal term, at least 5 years ago, is really the only relevant factor here. It's, you could have someone who murdered 50 people, but if somehow they got out of prison 5 years ago, they can probably still serve on your board.
Okay. Honey in Sanford again. We've never had a question like this before.
I can't wait.
Must there be a daily log of pool chlorine and pH? We only have 50 units and no maintenance staff, just a licensed pool service. Thank you.
So the short answer is no, but the longer answer is, it really doesn't matter the size of your community. That's not something that you're obligated to do, other than to the extent that you're tracking the safety of being in that pool. So if you've got local requirements that require you to measure that and make sure that the pH stays within a certain range and things of that nature, then you might be required to do that in order for the pool to remain open. But it's not going to be a condo or HOA statute related issue.
Ron in Orlando, if the board breaches fiduciary responsibility relating to a million things, I guess this guy's a little upset,
He doesn't
can the
like
board
the board.
be taken to small claims?
So the short answer is yes, but keep in mind that breach of fiduciary duty is not by the board, it's by the individual directors. So that doesn't mean you can't be going after the entire board if you feel that each one of them has breached their fiduciary duty, including more than once. Keep in mind, though, that if you're talking about small claims court, there's a limit. I think it's now 50,000 to what that small claims court can actually consider. So you need to look up, based on the dollars that you're looking to get back out of that claim, will small claims court have jurisdiction, or do I need to go to the county or even the circuit court in order to get that ruling and have the court be able to rule that you're entitled to this? Now, the other thing to keep in mind when you're talking about a breach of fiduciary duty, two things. One, what you're saying is that the association has a claim against these directors for breach of fiduciary duty. If it's an individual claim, it needs to individually impact you in some special way in order for you to be entitled to any recovery at all. The other thing to keep in mind is, as soon as that claim is brought, the first thing these directors are going to do is submit a claim to the directors and officers liability insurance carrier for a determination of insurance coverage. And chances are your insurance rates are going to go up, and you're going to be paying everything unless they are found in violation beyond what that policy covers, or beyond what the indemnification provisions in your governing documents allow the association or require the association to pay. So what I'm saying is, you're really suing the association, even if you're suing the directors, because the association is the one that's going to pay out for their defense.
Larry in Orlando, and this is another website question.
Okay.
Our management property manager stated to me that contracts do not have to be on the website. They only need to list the contracts. Is this correct?
Statutorily, it's correct. And surprisingly enough, that came up during one of my meetings today. So the statute requires a list of, they call them executory contract. What that means is which ones are active. So you don't have to have a list of every contract the association ever entered into, but you do have to have a list of which contracts exist. And I understand the question. I understand the concern that's implied in the question. Well, why don't we have to have all of those documents uploaded? Because some contracts, especially construction contracts and things of that nature, they may be more than 100 pages long with 150 to 200 pages of exhibits. If you use, for example, the AIA contract, which I really don't like and you probably shouldn't use. But the reality is you're supposed to be able to use the website to find the information you need in this respect. Then you can perform a records inspection request if you really want a copy of any individual contracts themselves. So the short answer is yes, the website requirement is generally only, and I just looked at it for an HOA. I think it's the same for a condo, but it's only that you actually have the list of what contracts are currently pending for the association.
You just got a text in from Marvin. He said, I always put away on my schedule your show each month. I can't thank you enough for giving so much great information. I really trust what you say. Oh my God, Alan. He said, what do you see AI coming into play for associations?
So I see it in record keeping. I see it in automating a lot of things. That in reality is where I see it playing a part. The other thing is a lot of smart devices being used in community associations, and we're already seeing some of that. But I can't even envision where it's going, because personally, I just started using ChatGPT about 2 weeks ago, and I don't really use it in my practice. I use it primarily in things that are personal because I don't want to give it any confidential client information. Even when it tells me that it's not going to train on that information and share it with anyone else, I just don't trust it yet. So unless we can create our own, firm-wide and specific to the firm, our own AI, I'm not trusting it yet. And I think there are a lot of people that are not necessarily like me, are not skeptical, and we can see the uses for it, but I don't think it's been looked at closely enough by people that are in this industry, because frankly, the community association industry overall can be very antiquated sometimes. So I think as we start to see the things in homes, in hotels, in other areas being automated and using AI, I think that's when you'll start to see, about a year or two after it starts to become almost commonplace, that's when you'll start to see it being commonplace in community associations.
And our final question of the day is from a listener on our chat line from Alberto. He wants to know, good afternoon. Florida's statute, our Florida state under 718, prohibits the use of debit cards by condo association. Is it permissible for a maintenance supervisor to use the association's credit card, not debit, for maintenance supply?
So there is no law governing credit cards with respect to community associations in general, but condos and HOAs both now have a criminalized penalty if you use a debit card that's either in the name of the association or paid directly by the association. If you don't have not only a meeting, but meeting minutes reflecting that this expense has been approved or that it's directly listed in the budget. So credit cards, I don't even care what the circumstance is. There's nothing in Chapter 718, Chapter 720, or 719 that talks about credit cards at all. And frankly, that's actually what I'm recommending, or at least suggesting to all of our clients that have been using debit cards for association business. Just switch over to a credit card so you don't have to worry about some frivolous criminal penalties being brought against you because you bought something at Home Depot for the association and you didn't get it approved at a board meeting in advance.
Well, as always, the show goes by so fast. Let's tell people how they can reach K. Bender Rimbaum.
Sure. So the firm as a whole can be reached at 954-928-0680 or our 1-800 number, which is 800-974-0680. That'll reach the front desk, so you can reach any of our attorneys or employees, and you can reach me directly. Either find me on LinkedIn, my name is right on the screen, or at my email, as@kbrlegal.com. Steve, thanks so much as usual. I appreciate it. And to all who made those kind comments, I don't know how much Steve's paying you, but I appreciate that as well.
I just thought they were your relatives. Listen, we love you, bro. We'll see you
Likewise.
again next month, and we love having you. We'll see you again next month.
All right, looking forward to it.
Always. That's board certified. I love how that sounds now. Board certified attorney, Alan Swartzide. Hey, Bender Rimbaum. Folks, thanks so much. We can't tell you how much we appreciate you taking the time to write these letters. And I know there's a lot that we didn't get to today. We'll save them for next month. That'll do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.